Ms. Dumont, I should have just sent you a copy of that warrant in the chat. Are you able to access that?
Yes. Your Honor, we've reviewed the motion and affidavit for the bench warrant.
All right, so the warrant alleges, Mr. McCormick, that you tested positive for cocaine in a drug screen on March 30, 2024, as well as April 6, 2024. The maximum penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the right to be represented by an attorney, and obviously you're represented by Ms. Dumont at this point. So, Ms. Dumont, do you know how Mr. McCormick wishes to proceed with this contempt?
Your Honor, we asked for the bench warrant to be quashed and set for a contempt hearing. I would like to see the results of that, those allegedly positive drug screens. And we would ask for a PR bond.
So I'll enter a not guilty plea on the alleged contempt. And I will issue a PR bond on that contempt with the requirements that he continue participating in all of the bond conditions that he's already required to participate in on the underlying charges.
Thank you.
Does he still want to enter into the plea agreement?
Yeah.
Yes, Your Honor.
All right. Go ahead then and state the terms of the plea agreement for the record, and then I'll ask Mr. Sneed to confirm.
Your Honor, the plea agreement indicates Mr. McCormick will plead guilty to attempted possession of a controlled substance in file 2421705FH, in file 2321747FH. He's going to plead to a fleeing fourth degree, attempted possession of a controlled substance, and operating with presence of a controlled substance. We previously got a Cobb's agreement in which he would not have to serve any more than 60 days in the County Jail at sentencing. The prosecutor still agreed to deferring that 60 days upon any violation of the terms of probation. So essentially a Killebrew to no upfront jail with the prosecution.
All right, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor. Thank you.
All right, Mr. McCormick, will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do, Your Honor.
You are Wesley Allen McCormick.
Yes.
And have you heard the statement of your attorney and the prosecuting attorney today, Mr. McCormick?
Yes, I have, Your Honor.
And is it your intention to plead guilty in file 24-21705-FH to count 1, possession of a controlled substance, cocaine, heroin, and other narcotic of less than 25 grams?
Yes, it is.
You understand that the maximum possible penalty for that offense up to 4 years in prison and or a $25,000 fine?
Yes.
Your Honor, I believe, I'm sorry.
Okay, in the 23 file, I'm sorry, he was pleading to the fleeing and eluding and the operating with a presence charges. Is that right?
Yes, and both the controlled substances are attempt.
Oh, I'm sorry. So I need. I apologize. So let me back up, Mr. McCormick, back to file 24-21705-FH. So your intention to plead guilty to attempted possession of a controlled substance of cocaine, heroin, or another narcotic less than 25 grams.
Yes, Your Honor.
And you understand the maximum possible penalty for the offense is up to 2 years in prison and or a $25,000 fine.
Yes, I do, Your Honor.
And in file 23-21647-FH, is it your intent to plead guilty to count 3, operating with the presence of a controlled substance?
Yes, it is, Your Honor.
And you understand the maximum possible penalty for that offense up to 93 days in jail?
Yes, Your Honor.
Is it also your intention to plead guilty in that file to 4th degree fleeing and eluding a police officer?
Yes.
And you understand the maximum possible penalty for that offense up to 2 years in jail and or a $2,000 fine?
Yes, I do, Your Honor.
And finally, in the 23 files, that your intent to plead guilty to attempted possession of cocaine, heroin, and other narcotic of less than 25 grams?
Yes. Yes.
And you understand again the maximum penalty for that offense up to 2 years in prison and or a $25,000 fine?
Yes, I do.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we've discussed it here today. Is that accurate, Mr. Sneed?
Yes, it is. Thank you.
Ms. Dumont?
Yes, Your Honor.
Is that also your understanding, Mr. McCormick?
What was the question?
Is that your understanding?
Yes.
Sorry, did you answer?
Yes.
All right. If a guilty plea is accepted, Mr. McCormick, there'll be no trial. That means you'll be giving up the rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. McCormick, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, I do, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I don't.
Do you understand that you're giving those rights up?
Yes, I do.
All right, in file 24-21705-FH, how do you plead to the charge that on or about December 30, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of attempted possession of cocaine, heroin, or another narcotic of less than 25 grams?
Guilty, Your Honor.
And in file 23-21647-FH, how do you plead to the charge that on or about August 11, 2023, in Adrian Township, Lenawee County, Michigan, that you did commit the offense of operating with the presence of a controlled substance?
Guilty, Your Honor.
And in the same file, how do you plead to the charge that on or about August 11, 2023, in Adrian Township, Lenawee County, Michigan, that you did commit the offense of fourth degree fleeing and eluding a police or fleeing a police officer?
Guilty, Your Honor.
And in that same file, how do you plead to the charge that on or about August 11, 2023, in Adrian Township, Lenawee County, Michigan, that you did commit the offense of attempted possession of cocaine, heroin, or another narcotic of less?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges? I'm sorry, I wasn't able to understand your answer.
No, they have not.
Okay. Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. McCormick to plead guilty?
No, Your Honor.
No, Your Honor.
All right. Mr. McCormick, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record this morning?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is.
Okay, Ms. Dumont, would you like to cover the factual basis?
Yes, Your Honor. So 2321647FH, on or about August 11, 2023, were you driving on Ben Oak Highway near Abbott Court?
Yes, I was.
Okay. And would you agree a marked police car activated their lights and sirens and tried to pull you over?
Yes.
Okay. But you continued to drive about a half mile
Correct.
and then pulled into the Sunoco gas station?
That's right.
Okay. Did you admit to the officer that you had consumed alcohol before driving?
I did.
Okay. And that as a result of that, you had a blood test done?
Correct.
Okay. And would you agree that the results of the blood test indicated you had cocaine in your system?
Yes.
Okay. And then would you agree that when the officer searched your vehicle, you had a bag of cocaine
Correct.
in the amount of 1.17 grams?
Yes.
Okay. And then in 2421705FH, on or about December 30th, 2023, did you make contact with the police in Fricker's parking lot off
I
of
did.
Main Street?
I did.
Okay. And at that time, did you possess a bag of cocaine weighing 6.3 grams?
That's correct.
Okay. And that was in your vehicle?
Yes.
Okay.
No, the bag was in my pocket, actually. I handed it to the police officer.
Okay. And would you agree this occurred in the city of Adrian,
Yes.
County of Lenawee, state of Michigan?
Yes.
Your Honor, I think we're satisfied with the facts.
All right, Mr. Sneed, are the people satisfied?
Yes, thank you.
Okay, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Ms. Dumont?
Yes, Your Honor. Thank you.
All right, I will accept the plea. It has been given understandably, voluntarily, and accurately. Mr. McCormick has had full knowledge of his rights and he's had competent counsel. Court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we've discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 23rd at 8:15 a.m. Okay, Mr. McCormick, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that, please be truthful about these offenses and about your background.
Yes.
I will also set the contempt of court for May 23rd at 8:15 as well.
Thank you.
All right, anything else we need to address with this case today?
Your Honor, if we could ask for one bond modification. He indicated to me Sunday, April 21st, there is a charity event with Special Olympics in Findlay, Ohio. He would like to attend and was invited to. If we could get permission for him to go to that.
It's just in the morning.
In the morning, he indicates.
Mr. Sneed, people have any objection to that?
No, thank you, Your Honor.
Judge, I'd be okay with that as long as we have positive or negative string or drug screens up until that point.
That's fine.
What was the date?
21st, Sunday.
April 21st.
Sunday.
Mr. McCormick, are you currently on probation?
Yes, upstairs with Tom, with Mr. Moore. Yeah, I'm a transfer from Ohio, actually.
All right, so as long as there aren't any additional positive drug screens, I will permit Mr. McCormick to travel to Findlay, Ohio to go to the Special Olympics event for that date.
Thank you.
Thank you.
All right, and then Mr. Dickerson and Ms. Devon, I'm going to put you in a breakout session with Ms. Walsh so she can collect your contact information.
Okay, thank you.
I don't need that, Judge. He's on probation.
What phone number do you have of mine? I don't, I got a new number.
Yeah, let me put you in a breakout session because I don't want that information being.
Thank you, Your Honor. Thank you, Your Honor.
Okay, Ms. Underwood, Mr. Jones, I apologize. I clicked the wrong button and ended your breakout session. You need to put you back in it.
Thank you.
And Mr. Daly, do you need a breakout session with Mr. Edwards?
No, Your Honor.
Okay. All right, we are on the record then in files 24-21781-FH, 24-21782-FH, 24-21783-FH, and 21-21784-FH. 21784-FH and file 24-21785-FH. Those files are all set for arraignment this morning. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
James Daly on behalf of the defendant.
All right, Mr. Daly, does Mr. Edwards wish to have the information read?
We would waive the information, Your Honor.
All right, and have you received the prosecutor's witness list and request for discovery?
I have, Your Honor.
And how does Mr. Edwards wish to proceed today?
He plead not guilty at this time. And I would also indicate to the court there was a plea bargain that has been offered in this matter. I've discussed that with Mr. Edwards, and he has rejected it.
All right, I will enter a not guilty plea for Mr. Edwards then in each file. And so, Mr. Daly, how would you want to proceed if the plea offer has been rejected? Do you want to just set it for trial? Or would you like another pretrial to see if you can have further negotiations?
I just assume set it for trial, Your Honor, and if we can get it worked out, we can, but I'm not optimistic about that happening.
All right, so the lowest file number would be the 782 case. That's a delivery manufacturer of controlled substance. Is that the one we're going to try first?
Yes, Your Honor.
Oh, I'm sorry, there's a 781 case. There's actually a lower file number.
Oh,
So that's a possession of methamphetamine and operating while intoxicated, and operating with license suspended, revoked, or denied.
yeah, well, we can do that one, Judge. Thank you.
Okay. And how much time do you think you'll need for that case?
Maybe 1.5 days.
Okay, so Ms. Clark will need, can you find us a 2-day jury trial date, please?
August 15th at 9 a.m. and August 16th at 9 a.m.
It works for the people.
It works for me, Your Honor.
Okay, let's set a final pretrial then for August 7th at 8:15.
I'm out of town that day, Judge.
Okay, the week before would be July 31st.
That works.
Judge, you have that off for vacation.
Okay, the week before that would be July 24th.
That's fine, Judge.
Okay, so final pretrial July 24th, trial on August 15th and 16th. The court will issue a scheduling order. Set all the other cases for a pretrial also on July 24th at 8:15. Is there anything else we need to address in Mr. Edwards' cases today?
I have nothing, Your Honor.
No, thank you, Your Honor.
Okay, he had a couple files, the 782 and the 784 cases It looks like he had a contempt of court from down in district court that hasn't been resolved yet. Just want me to set those for the same pretrial date, Mr. Daly?
Yes, Your Honor.
Okay, so that's what we'll do with those. All right, so the court will issue a scheduling order for the trial dates. Thank you for your time then, Mr. Edwards. You can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
Thank you. Okay, Ms. Underwood, are you ready to proceed with Mr. Jones?
Yes, I think so, Your Honor.
We are on the record in file 24-21712-FH, People versus Javon Anthony Jones. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed. Sorry, Mr. Sneed, if you said anything, you were muted.
Oh, sorry. Isaac Sneed for the people.
Rhonda Underwood for Mr. Jones, Your Honor.
Okay, and Ms. Underwood, where do we stand with Mr. Jones' case today?
Mr. Sneed, did you get my text?
I did, and I replied, yes.
After that.
Yeah, I have no objection to that.
Okay, thank you. Your Honor, we have worked out a plea bargain in this matter whereby Mr. Jones will plead guilty to attempted assault of a prison employee, a 30-month felony, and there will be a Killebrew to the low end of the guidelines, and the 5-year and the subs will be dismissed, Your Honor.
All right, I'm going to need an amended information for that.
Understood. We're working on that, Judge. I'll follow up.
Okay. All right, Mr. Malaro, I have Mr. Dickerson here. If you are ready to proceed with him. Mr. Mawad, I believe that Mr. Samuelson is here in the courtroom. If you need a breakout session, do you need a breakout session with him?
No, thank you, Judge. No.
Okay, so we'll get to that one. We'll get to that one after we do Mr. Dickerson. Mr. Dickerson, can you hear me? All right, Mr. Dickerson does not have his audio connected yet, so Mr. Samuelson. All right, we are on record in file 23-21614-FH, People versus Timothy Preston Samuelson. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Elias Muwad appearing on behalf of Mr. Samuelson.
All right, and Mr. Malad, where do we stand with Mr. Samuelson's case today?
Judge, I got a call from the forensic center saying that they forgot to do a culpability. As a result of that call, Mr. Samuelson went in yesterday to do the culpability. And I did talk to Phoebe this morning. What we're thinking is it's going to probably take about 45 days to get the culpability report, but I'm hopeful that by the time we come back, as this case is getting old, is we resolve it in some form of a plea.
Mr. Sneed, anything to add from people's side?
No, that's all accurate, Judge. We have no objection. Thank you.
Okay, so 45 days to give that amount of time, we'll be looking at May 29th.
Yes, I should have it by then, Judge, and hopefully we can resolve it out. I have a vacation plan the week after, so I really would like to see a finality to this case for myself and Mr. Samuelson.
Okay. So let's set it for a pretrial on May 29th at 8:15 a.m. And Mr. Mawad, would you do a stipulation in order for that adjournment?
I will. Isaac, can I sign your name?
Yes, please. Thank you.
Okay. Thank you, everybody. Thank you, Judge.
All right. So Mr. Samuelson, you're all set for today. Your next date is May 29th at 8:15. Thank you. Okay, thank you. Lakers.
Good. This is Kelly. Could we Trenton Green Laker for Judge Olson? Green Laker.
Hi, Mr. Dickerson, are you able to hear me?
Yes, sir.
All right, we are on the record in file 24-21739-FH People versus Sean Davis Dickerson. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Sean Dickerson.
All right, and Mr. Malero, where do we stand with Mr. Dickerson's case today?
Judge, you're still preparing or doing some further investigation of the matter. I might ask for another pretrial. That would be my basis. And then I'd like to address Mr. Dickerson's bond conditions of drug testing.
All right, let's go with a pretrial on May 22nd at 8:15 a.m.
Perfect, Judge.
And, Mr. Miller, would you do the stipulation in order for that adjournment?
I would.
All right, and what do you want to discuss about Mr. Dickerson's bond?
So, Judge, this is an uttering publishing case. Mr. Dickerson has drug testing requirements. It's my understanding from Mr. Coates that he has not had any negatives since he's began testing. It poses a significant financial burden upon him. I'd ask the court to consider terminating the drug testing requirement. He's demonstrated that he is not currently using. And it is not, as far as I can tell from reviewing the complaint and the information, drug use is not an element or a portion of why this case was brought.
Judge, he started drug testing back February the 23rd. I've gotten back about 10 results. They're always completely negative. I wouldn't be opposed to that request.
Okay, Mr. Sneed, anything from the people?
I defer to the court's discretion, Your Honor. Thank you.
Okay, so just looking through the file, I don't see any indication that substance abuse played a role in this. It's a case about writing bad checks, and given that, and I haven't been made aware of any drug history that Mr. Dickerson has. And the fact that he's been testing negative since February, I think it is appropriate to eliminate the drug screening provision. So I will modify the bond in that way at this time.
Judge, would you like a separate order to that effect?
No, I think what we do is a new pretrial order with that will have that, or a pretrial release order that has that change in it.
Okay, all right. Thank you, Judge.
So I think we're there. So Mr. Dickerson, you are all set for today. You can go ahead and log out.
All right, when was the next pretrial, Your Honor?
May 22nd at 8:15 a.m.
All right, thank you very much.
Okay, thank you. All right, I've got the amended information for Mr. Jones, so we can return to that case.
Thank you, Your Honor.
Back on record in file 24-21712-FH People versus Javon Anthony Jones. We are again proceeding by video conference, and I do now have the amended information. So Mr. Jones, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Javon Anthony Jones?
Yes, Your Honor.
Mr. Jones, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, attempted assault of a prison employee?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $2,500 fine?
Yes, Your Honor.
2.5 years.
All right, yeah, that should be 2.5 years. All right, Mr. Jones, I apologize. You understand maximum possible penalty for that offense is up to 2.5 years in prison?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is. Thank you.
Ms. Underwood?
Other than the plea agreement, Your Honor, that's correct.
Yeah, I apologize. Other than as the plea agreement has been stated on the record here today. Is that also your understanding, Mr. Jones?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Jones, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about October 27, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted assault of a prison employee?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you will be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Jones to plead guilty?
No, Your Honor.
Your Honor, I don't know if we put this on, but there is a Killebrew to the low end of the guidelines. And I know we talked about it before the case was called, but there is a Killebrew to the low end of the guidelines.
I believe we discussed that the first time that we were on the record.
Right. I just wanted to make sure.
Okay, so Ms. Underwood, are you aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Jones?
No, Your Honor.
Mr. Jones, other than as we've discussed on the record this morning, has your attorney promised you a particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, Ms. Underwood, do you want to cover the factual basis?
Certainly, Your Honor. Mr. Jones, back on October 27th, 2023, were you an inmate at the Gus Harrison facility located in Madison Township, Adrian, Michigan, Lenawee County, state of Michigan?
Yes, ma'am.
And when you were an inmate there, on that date, did you assault or attempt to assault Keith Pickford, an employee of the Gus Harrison facility?
Yes, ma'am.
And you knew he was an employee of the facility?
Yes, ma'am.
And you did not have his permission to assault him, correct?
No. Correct.
And you did that by swinging at him, correct?
Correct.
Your Honor, I believe I've established the factual basis.
Mr. Sneed, are the people satisfied?
Yes, thank you, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Ms.
Yes,
Underwood?
Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Jones has had full knowledge. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 23rd at 8:15 a.m. Mr. Jones, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
Okay, and it looks like we do need fingerprints for Mr. Jones before sentencing, so we're gonna need an in-person writ for the sentencing hearing, Mr. Sneed, so that we can get his fingerprints taken.
Understood. Thank you.
That's in person, Your Honor?
Correct.
Thank you.
All right, Mr. Jones, you're all set for today. Then you can let the officer that's with you know that you're done with court. Okay, is there a Mr. Goodlow here? Yes. All right, Mr. Goodlow, you need to come up and sit at this table closest to the television. And is Ms. Ungst here? Okay, you can, if you want, come up and sit at this table, or you can stay where you are. It doesn't matter. All right, we are on the record in file 23-51145-PP, Ashley Cole Ungst versus Daryl Denard Goodlow Sr. We are here today for a hearing on a show cause related to an alleged violation of a personal protection order. Miss, you are Ashley Nicole Ungst.
Yeah.
And sir, you are Daryl Denard Goodlow Sr.
Yes, sir.
Mr. Goodlow, have you received a copy of the order to show cause?
Yes.
Okay. You are before the court today on that order to show cause. The show cause alleges that you violated a personal protection order on March 22nd by contacting Ms. Ungst by telephone. The maximum possible penalty for a violation of personal protection order is up to 93 days in jail and or a $500 fine. You have the right to be represented by an attorney here today and at any other hearings that we have in this matter. If you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney?
Yep. Yes, sir.
Do you have the ability to pay for your own attorney? Okay, so I'll appoint the public defender's office. Sergio, is the iPad set up?
No, I can do that.
Can you go set that up and then take this to Francis and have her scan that to Rhonda? So Mr. Goodlow, if you want to step outside to the hallway, there's an iPad out there where you can speak to the public defender. And Ms. Ungst, if you will just take a seat back there.
This is Mr. Goodlow, Your Honor.
Yes, it is. All right, let's see. So the gentleman at the jail, you are Mr. Green Blaker. Was not able to hear. I can't hear you, sir. You need to get closer to the device.
Yes, Your Honor.
All right. Okay, Ron, I'm going to have you speak to Mr. Green Blaker first, if that's all right.
That's fine. Mr. Green Blaker has a case that is pending in district court where his next date is 5/14. Can I just talk to Mr. Green Blaker for just a second?
One second. Okay, Mr. Goodloe, where'd you go? There you are. Okay, so Ms. Underwood is speaking to another one of her clients right now. As soon as she's done with his case, I'll have you speak to her.
Excuse me?
Yeah, I know. Three rooms if they don't put equal knowledge rooms.
Yeah, that's what I was saying. Like, he basically like, it's your choice, bro. If you want to get off or if you want to get locked back up, like, you know what I'm saying? So, if you really want to get off, we'll work with you for time. If you're just,
Thank you. Yes, please. Thank you.
Sorry. Just stay in front of that iPad. I put it in the waiting room. What?
he wants to represent himself. No attorney.
Okay. All right, you can come back in and sit down. All right, we are on the record. Sorry, this. We are on the record in file 23-21274-FH People versus Trenton Jonathan Green Blaker. We are here today for a hearing on an alleged probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Green Blaker this morning, Your Honor. Thank you.
All right, and where do we stand with Mr. Green Blaker's case today, Ms. Underwood?
Mr. Green Blaker has this violation, Your Honor, for failure to report. However, he does have a case in district court that would, of course, if found, be another violation. So we're trying to get that taken care of. And I believe Ms. Walsh has no objection to another adjournment in this matter. And I've discussed the matter with Mr. Green Blaker. So if we could have an adjournment till after the 14th.
After May 14th?
That's correct, Your Honor.
All right, let's do May 15th at 8:15.
I'm sorry?
May 15th at 8:15.
Thank you, Your Honor.
All right, Mr. Green Blaker, you can let the officer that's with you know that you're done in court for today. Ms. Underwood, would you do that stiff order? Oh,
Will
actually,
I
there's
do-
no one to stipulate to that, so we'll just do a notice.
Thank you.
Okay, so let's go back to file 23-1145-PP. Umst versus Goodlow. So Mr. Goodlow, you had gone out to the iPad to meet with someone from the public defender's office. It's my understanding you communicated to bailiff that you do not at this point wish to be represented by an attorney. Is that correct?
Yes, sir.
Okay, and you want to represent yourself?
Yes, sir.
All right. So your options at the moment are to plead guilty or not guilty to the alleged contempt. Do you know what you want to do?
Not guilty.
All right, so I will enter a not guilty plea for Mr. Goodlow, and we will set this for a hearing date. Ms. Clark, can you give us a probably about a 1 hour hearing date for the contempt trial in this matter?
April 25th at 1:30.
Are you both available that date and time?
I'll probably have to take more time off of work.
So we'll set it for a trial on April 25th at 1:30 p.m. So the trial date is both of your opportunities to present any witnesses or other evidence that I need to know about before making a decision. If you have witnesses that you want me to hear from, they need to be here in person along with you in order to testify. I can't take written statements or letters or anything like that from other people. They have to be here to testify themselves. Do you understand that?
I do have a question, Your Honor.
What is your question?
He violated it again this past Saturday, and I filed another show cause, and I actually picked it up from the clerk's office before I walked in this courtroom this morning, and it's the court date for May 1st for that one. Is there any way we can either serve him with that, or we can group these together? That's two different violations.
So he's required, or he's entitled to a certain number of days' notice of the show cause order before I can require him to appear at a hearing for that.
Okay.
Mr. Goodlow, if you want to waive your right to that notice period, and
Not waiving anything.
I'm sorry?
Not waiving anything.
Okay, so we will, if you, Sergio, do you want to track down a copy of that so we can serve it on Mr. Goodlow today, right now, and then we'll have to have that hearing on whatever date was set for in order.
I have his copy, Your Honor.
Okay, so if you want to, oh, all right. I apologize. He cannot be served in court, so you're going to need to make arrangements to have him served on.
Okay.
And we will go forth with the hearing date on whatever date set forth in that order. Okay, so April 25th at 1:30 p.m. is the trial on the first alleged case. So we will see you back.
Thank you, Your Honor.
Thank you. Okay, Mr. Malero, do you need to speak to Mr. Madrid?
Yeah, that'd be good, Judge.
Okay, Mr. Madrid, I'm going to put you in a breakout session with Mr. Malero if you give me just a moment.
Okay, sir.
Mr. Glazer, do you need to speak to Mr. Blass?
Your Honor, we adjourned Mr. Blass last week or actually 2 weeks ago, and because we needed to order the transcript.
Okay, Mr. Glazer, I'm sorry to interrupt. I just need to know whether you want a breakout session with them or
No,
can we go on?
I do not.
Okay. All right, we are on the record then in file 24-21771-FC, People versus Andrew Aaron Blast. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
John Glazer on behalf of Mr. Blast.
All right, Mr. Glazer, where do we stand with Mr. Blast's case today?
Yes, Your Honor, we adjourned it on the April the 3rd to get a transcript of the waiver down in district court. Reason being, Ms. Meir and I had a miscommunication about what was offered, and I want to see what was said at the waiver. We've requested that just on a disc, actually, and haven't gotten it. So we'd asked to adjourn it out a short time, and I'll have my secretary check on it again to see why we haven't received it. But I checked with them this morning, and we do not have it yet.
Okay, how about next week, April 24th?
Yeah, that'll work, Your Honor.
No objection.
Mr. Glazer, could you do the stip in order for that adjournment?
Yeah, we will, Your Honor.
All right. All right, Mr. Blast, then you can let the officer with you know that you are done with court for today, and we will see you back next week at 8:15.
Thank you, Your Honor.
Okay, Ms. Underwood. Mr. DeVries is apparently refusing to leave his cell to participate in the hearing, so I'm going to call that one.
Excuse me, Judge.
Yeah.
The prison called and said they were able to talk him to come out of his cell, so they were gonna get him down to their courtroom and dial in.
Okay, so we'll wait a few minutes to see if he shows up.
Thank you, Your Honor.
Okay, Mr. Dagger Margosian, I believe I have Mr. Cast here. Give me just a minute.
Thank you.
All right, Mr. Cast, can you hear me? His audio is not connected yet. Mr. Cast, can you hear me now?
Okay, yes, I can hear you now.
All right, Mr. Dagger Margosian, do you need a breakout session with Mr. Cast?
No, Your Honor.
All right, we are on the record in file 24-21796-FH, People versus Tyreek Wayne Cast. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Mr. Cast.
Okay, and Mr. Dagger Margosian, does Mr. Cast wish to have the information read?
No, Your Honor, and we're actually in a position to enter a plea today.
Okay, what do you want to go ahead and state the terms of that plea agreement, and then I'll ask Mr. Sneed to confirm.
Your Honor, in speaking with Ms. Wagner in district court, we did reach a resolution where Mr. Cast will be pleading guilty to 1 count of R&O, 1 count of DV, and 1 count of A and B, all being under HIDA. The remainder of the information would be dismissed.
Okay, I'm sorry, that was 1 count of resisting and obstructing, and then the domestic violence and the assault and battery, new charges added to the amended information, is that right?
Correct, and the court should have an amended information.
Mr. Sneed, is that a complete and accurate statement of the agreement?
Yes, it is, Your Honor.
Okay, Mr. Cast, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I swear, Your Honor.
And you are Tyreek Wayne Cast?
Yes, Your Honor.
You can put your hand down if you like. Mr. Cast, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, police officer assaulting, resisting, obstructing?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 6, domestic violence?
Yes, Your Honor.
And do you understand the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine?
Yes.
And is it also your intention to plead guilty today to count 7, assault or assault and battery?
Yes, Your Honor.
And do you understand the maximum possible penalty for that offense is 93 days in jail and or a $500 fine?
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with courts. Is that correct, Mr. Sneed?
Yes, it is. Thank you.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Cast?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cast, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about March 27, 2024 in Clinton Township, Lenawee County, Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty, but I think it's Clayton, Your Honor.
Okay, that should be Clayton Township and not Clinton. Is that what you're saying?
Yes, that's correct.
Okay. And how do you wish to plead to the charge that on or about March 27, 2024 in Clayton Township, Lenawee County, that you did commit the offense of domestic violence?
Guilty.
And how do you wish to plead to the charge that on or about March 27, 2024 in Clayton Township, Lenawee County, Michigan, that you did commit the offense of assault or assault and battery?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Understood, Your Honor.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cast to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Cast, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Dagger Margosian, do you want to establish the factual basis?
Mr. Cast, as the court indicated on March 27th of this year, were you in Clayton Township, County of Lenawee, State of Michigan?
Yes.
And on that date, was there a physical altercation with Ashlyn Cast?
Not that I'm aware of.
All right, but you don't dispute that occurred, you don't dispute that occurred?
No.
Okay, and she's your sister?
Yes.
All right, and similarly, was there a physical altercation with Patrick Cast that you don't dispute?
He said it never occurred. So, no.
Were you wrestling with Patrick Cast, who is your father?
He just held me for a second, but we never had an altercation.
Okay, to accept the plea, we have to have a factual basis. So let me just ask this question again. You said that he held you, and would you agree that you were fighting back with him physically?
Yeah, I suppose, yes.
Okay, and you don't dispute that allegation?
Nope.
Okay. And and he's your father?
Yes.
Okay. And the police were called for this incident, correct?
Just the sister part, not my father. That was as they were driving down the driveway.
Okay. And so law enforcement responds to that address, and do you agree that you had a physical altercation with one of the officers?
Yes.
Okay. And you knew that you don't dispute that he was a law enforcement officer?
Well, I don't remember that part.
You don't dispute that individual was a law enforcement officer?
Nope.
Okay. And they were giving you direct commands, and you had refused those commands?
Don't dispute it.
Okay. I'm satisfied, Your Honor. Oh, I should the law enforcement officer was an individual named Justin Ott. You don't dispute that?
Nope.
Okay, I'm satisfied.
All right, Mr. Sneed, are the people satisfied with the factual basis?
Yes, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, it has. Thank you.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Ott has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've stated on the record here this morning. I will refer this matter to probation department for a pre-sentence investigation and set sentencing for May 24th at 8:15 a.m. Mr. Cast, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Understood, Your Honor.
Okay, I'm going to put you in a breakout session with Ms. Walsh from the probation department so she can collect your contact information.
Your Honor, but before that happens, may I address 2 conditions of bond?
Yeah, go ahead.
First, I received word from Mr. Coast that Mr. Cast is doing well on the once a week testing, and Mr. Coast is okay with discontinuing that at this point. So I would request the court to by bond in that way. Second, there's currently a no go to the listed address. I spoke with Ms. Wagner on that matter, and both of the sisters as well as the father are in support of removing that no go to condition. So I'd ask the court to modify that as well. And I did send the emails from the family members to Ms. Wagner. I don't know if it got to Mr. Sneed.
Okay, Mr. Coast, are you in agreement then with discontinuing the testing?
I am, Judge. Right now, he's just testing once a week, and it is for a swab, which is it is a hardship for him for paying that. And it was basically just making sure that he's taking his anti-anxiety medications as directed. And the results that I did receive, he is taken as Abilify. So no other substances were in his system. So yeah, I'm in agreement with that for him to go off the testing.
All right, and Mr. Sneed, anything from the people's standpoint?
No objection to that request, Your Honor.
How about the no contact or no go to address provision? Is that?
That's also agreeable with the people. Thank you.
All right. All right, so I'll modify the bond conditions at this time to eliminate the drug testing provision and the provision that prevents him from going to that address.
Thank you, Judge.
Thank you, Honor.
Okay, and now, Mr. Cast, I'll put you in a breakout session with Ms. Walsh from the probation department so that she can get your contact info.
Thank you, Your Honor.
Okay, Mr. Malero, are you ready to proceed with Mr. Madrid's case?
Yes, Judge, I'm ready.
Your Honor?
Yes.
After you're done with this, could we do Mr. Torres? I can do that without him being on Zoom. Without him being present.
Okay, we don't need to.
Oh, wait, we don't want,
Sorry, ask.
I guess we don't want him instead. Can we say, no to rest, Bush, what we do want Bush policy. Thank you. All right, thank you.
Okay, so we are on the record now in files 24-21750-FH, 22-20972-FH, 22-20969-FH, and 22-20968-FH. People versus Michael Anthony Madrid. We are here today for pretrial conferences in sorry, there we go. Pretrial conference in the 24 case, and contempt of courts and I think a probation violation in the older cases, the 22 cases. So first, let me ask the attorneys to place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Michael Madrid.
Okay, and Mr. Malero, then where do we stand with Mr. Madrid's cases today?
Here, I'm going to ask for an adjournment. I'm going to ask for 14-day, 2-week adjournment to discuss this matter with Mr. Sneed, and Mr. Madrid did make a request of me that I would need to look into that. So I think 2 weeks would be sufficient to know if we're going to be able to resolve this and or set it for trial. And then we'd ask that the probation violations or contempts be set out 2 weeks as well.
So 2 weeks would be May 1st. Mr. Sneed, is there anything we need to address from the people's side?
I just point out to Mr. Malero that this is Prosecutor McCready's case, so he can reach out to him to discuss the plea.
So May 1st at 8:15 a.m. Mr. Malero, would you do the stipulation in order for adjournment?
Yes, I will, Your Honor.
All right, anything else we need to address with Mr. Madrid's case today?
Not at this time, Judge.
No, thank you.
All right, thank you, Mr. Madrid. You are all set. You can let the officer with you know that you're done with court for today. Okay, so we can do Randy Torres then.
Yes, Your Honor.
All right, so we are on the record in file 22-20819-FH, 22-20820-FH, and 23-21668-FH, People versus Randy Torres. We are here today for pretrial conference in the 23 case and probation violations, I think, in the other cases. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
John Glazier on behalf of Mr. Torres, Your Honor.
All right, and Mr. Sneed, or I'm sorry, Mr. Glazier, you had indicated, I think, off the record that you are okay with proceeding without Mr. Torres being present from jail. Is that right?
That's correct, Your Honor. When we were here the last time, we had asked for a competency and criminal responsibility on the not on the VOPS, but on the underlying or the new charge, the possession. And we sent that over to your office, Your Honor, March 6th, and we've never gotten the orders back. So there's obviously a misfire somewhere. And
okay, the orders have been signed. They were signed on March 13th.
Okay.
And we'll make sure, actually, criminal responsibility, well, I don't know if that's a typo, that says February 14th, so.
Yeah.
At any rate, they've both been signed. We'll make sure that you get copies of those.
Okay, so we I don't know how long the court wants to adjourn this out, but it's once we get those orders and get them in, it's going to take 60, 90 days easy.
let's set it for June 26th at 8:15. That's a little more than, it's about halfway between 60 and 90 days, or a little closer to 60. So set it for that
Yeah, okay, June 26th at 9 o'clock.
at 8:15.
Oh, 8:15, okay.
And we will see where it stands with them.
Yeah,
And put a,
once
put
we
a-
get
put a
those
stick-
orders, we'll get everything started, Your Honor.
All right, we'll get those over to you today.
All right, thank you. That's all I have with you, Your Honor.
Okay, until Mr. Silvertooth at 11.
Yeah, Your Honor, I was gonna tell you, in regards to that, I've talked to Mike. Mike is going to be handling that. I don't know if you were ready to rule on the motion to quash yet or not, whether you've had a chance to review the transcripts. But the other thing, the motion to sever, he and I had a lengthy discussion with Mr. Silvertooth yesterday, and we may withdraw that motion, but we want to talk it over, and we were wondering if maybe we could adjourn that particular motion till the date of the pretrial.
Okay.
So the motion to quash, I don't know if you're ready to rule
All
on
right.
it.
So so if he's going to be here at 11 to deal with that, I'll just wait and we'll deal with that on the record.
Okay, but I just talked to Mike, and that's kind of what he's gonna ask. I got a meeting at 11, but I may be back on at the end of that, hopefully, and get on there. But if not, Mike's gonna handle it.
Okay.
All right, thank you, Your Honor.
All right, thank you. And so Mr. Malero, do you need a breakout session with Mr. Paulding?
I suppose so, Judge.
Okay, Mr. Paulding, if you hang on 1 minute, I'm going to place you in a breakout session with Mr. Malero. Okay, Mr. Goldstein, are you there?
Yes, Your Honor.
Let me just check one thing. All right, I have someone here by telephone only. Last four digits, your phone number 4252. Can you tell me your name?
Teresa Perez.
I'm sorry, I wasn't able to understand what you said.
Teresa Perez.
Oh, all right.
Perez, I believe she said.
I'm sorry?
Okay, Ms. Perez, I'm going to put you back in the waiting room for just a couple of minutes, Ms. Perez.
Okay.
Okay, so I have, where'd he go? Mr. Crone was here just a second ago, and now, all right, I have lost Mr. Crone, Mr. Goldstein, but we have Mr. Lyles here. Do you need a breakout session with Mr. Lyles?
No, Your Honor, we're ready.
Okay. We're on the record then in files 22-20789-FH and 23-21433-FH. People versus Jacoby Wayne Lyles. We are here today for pretrial conference in the newer case, and I believe a probation violation in the older case. 23 case is actually set for a final pretrial conference ahead of a trial date on April 26th. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, and so we're set for trial on April 26th. Mr. Goldstein, are we ready to proceed to trial on that date?
Well, we are, Your Honor, except that this is a case that I thought would be resolved, but I've never received any offer from the people.
Mr. Goldstein, a couple times ago, you had indicated that you didn't receive the offer, and then we adjourned it because you found the offer last minute. The offers plead to count 1 and OWI first offense.
Okay, I will talk to my client between now and next Friday, and we'll get this matter resolved. Your Honor, as far as the violation is concerned, I would suggest putting it over till next Friday. If we get the new case resolved, we should be able to wrap that into it.
All right. All right, so again, trial date is April 26, 2024. So next Friday, I understand there's going to be an effort to resolve, but if not, you should be prepared to proceed with trial on that date.
We'll do that, Your Honor. I do want to address the court on the issue of the bond condition, if I may, Your Honor. Mr. Lyles has been on a tether. Is it a GPS tether, Kobe?
It's an alcohol tether. I've been on it for 11 months.
Okay, and to my knowledge, Your Honor, at least since I've been in the case, there have been no violations. No violations have been reported to me. Although I know there's a violation of probation on the old file, but I don't know what that violation is. Mr. Lyles, now that weather has improved, Mr. Lyles, among other things, works with boats, which means he has to be in and out of the water. And having an electronic device in his possession when he does that is a little bit, we don't know what effect it's going to have on the device itself. But given the fact he's been on for 11 months and no violation of that has been reported to me, I would ask that the court allow him to stop using the tether. We have a trial date or a final date coming up next week. I don't think there's going to be any extended period of time, so I would ask the court to allow him to take off the tether.
Mr. Bayoneto, people have a position on that request?
Yes, Your Honor. Mr. Lyles has a pretty extensive history of this exact type of conduct when he's not being closely supervised by a court. And I think the fact that he hasn't had any violations speaks to that. It's because he's under the close supervision of the court. Your Honor, I think there's a fairly high likelihood of conviction when we come back next Friday. Again, I think we should be able to have this resolved within a week. So I think any bond modification at this point would be premature.
Your Honor, I'm not sure what Mr. Bayoneto was referring to when he says my client has a long history of this type of behavior. This is charged as a second offense, not a third or a subsequent, but a second offense. And the prior was 5 years ago.
Your Honor, I can clarify that. I apologize. The history spans back to Mr. Lyles' conduct in Texas. He has a long history of becoming intoxicated, and then coming into contact with police, and some sort of escalation always seems to happen when Mr. Lyles has been drinking and he comes into contact with police. I know he has multiple resisting arrests down in Texas, in addition to the resisting arrest and domestic violence that has the probation violation pending. And if I'm not mistaken, Your Honor, I believe alcohol was a factor in that prior case as well. That's what I'm referring to when I speak to Mr. Lyles' long history of reacting poorly when under the influence of alcohol.
All right, I think we've had this discussion before, and I've expressed my concerns about similar situations or with what occurred in the last case, Mr. Lyles was intoxicated. Is Mr. Lyles, Ms. Golson, is he doing anything other than the tether to address alcohol use?
I do not believe so, Your Honor.
I'm actually trying to at this point, like I'm done drinking because my kid's mom's gonna use anything she can against me to where I can't see my son. And my son's more important than a bottle of booze. I feel healthier. My dad has got actually health problems due to drinking, and I don't want to long distance have health problems. I'm trying to better my life for health reasons, and I'm done with the lifestyle I've been choosing to live over the years. Have made mistakes, but my son is more important than a bottle of booze, and it's sad that it's taken me this long to realize that. But when I moved up here 4 years ago, I was dealing with the loss of a child, and that kind of drug me down to drinking. So, I mean, the way I look at it, I got a little boy up here, and he needs me here, not drunk and doing stupid things. So I'm done drinking. Like, I've realized what I've lost over the years because of it, and I'm done. Like, it's not worth what I lost. I've lost 2 relationships with 2 good women. I've lost time with my children, and I'm done.
All right. So we have gone 11 months. That is a significant period of time during which Mr. Lyles apparently has not consumed any alcohol, because I've not heard anything about any positive tests or positive responses from the
Judge, that is true. He is on Scram, so it is 24/7 monitoring. I have not received any violations.
So I think based on that, I'm willing to modify the bond to eliminate the Scram unit. And it must continue to not use any alcohol, marijuana, or any controlled substances. I am going to require that Mr. Lyles participate in an Alcoholics Anonymous program and get that established immediately, because I do think while the concern is reduced at this point, I think there are issues that need to be addressed in order for us to be assured that it's going to continue without the presence of the 24/7 monitoring. So I will modify bond in that fashion.
Thank you, Your Honor.
All right, so Mr. Lyles, your next date is Friday, February 26th. You need to be here in person for that trial unless a resolution is reached and placed on the record before then.
Yes, sir.
I'm sorry,
Now, do I go today to get the tether off, or?
Call Mr. Coast and work it out with him.
Yes, sir.
Jacoby, what I'm going to do is I'm going to go ahead and contact JSG so you can return that immediately then.
Okay, I'm at work right now, so it'll probably be like right before they close.
Okay. That's fine.
Okay, I'll be in touch, Jacoby.
Yes, sir. Thank you.
I believe we have Mr. Crone, Your Honor.
Okay, Mr. Crone, I'm going to send you a request to unmute. I think that's Mr. Crone. So Mr. Lyles, you can go ahead and log out.
All right, thank you, sir.
Hello.
All right, the gentleman at the MDOC facility, are you Mr. DeVries?
Yes, sir.
Okay, Mr. DeVries, I'm going to put you back in the waiting room for a few minutes. Your attorney had gone over to the other court to handle some cases there. As soon as she's back, I'll have you brought back in and speak to her.
Yes, sir.
All right, we are on record in file 23-21520-FH and 24-21715-FH People versus Jason Ansel Crone. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, Mr. Goldstein, where do we stand with Mr. Crone's cases today?
Your Honor, an offer has been made by Mr. Sneed on behalf of the people, which my client is going to accept. Basically, he's going to plead guilty to count 2 in each file. In the file ending in 520, it's a charge of retail fraud. And in the other file, he's going to be pleading guilty to count 2, which is a charge of larceny from a motor vehicle. In exchange, the people are going to dismiss count 1 in each file. And I don't see a habitual notice in here, but I assume if there is one, it's going to be dismissed. There is no sentence agreement, Your Honor, but my client is going to be asking to be screened for drug court. The court is aware that he does have a serious drug problem. He has completed rehab on his own during the pendency of this action, but he thinks he would benefit from the drug court program.
Okay, so in the 23 file, it's a retail fraud with a second offense notice. I'm sorry if you said what's happening with that, I missed it.
There was no habitual file. Mr. Sneed did not make it clear whether the notes in the information itself would be dismissed. I was referring to the general habitual.
Okay, yeah, so there's a habitual in the 24th. So Mr. Sneed, you're dismissing that?
There will be no habituals in either file, Judge.
Okay, and then what about the second offense notice on the retail fraud?
I believe that stands as part of the charge.
Okay, is that, Mr. Goldstein, a part of the agreement?
Yeah, well, in a negative way, Your Honor, in the sense that Mr. Sneed never offered to dismiss it, so we understood he would plead guilty as charged.
Okay, all right, I just want to have that clearly stated on the record.
Thank you.
So, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is. Thank you.
Okay, Mr. Crone, would you raise your right hand, please?
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Jason Ansel Crone?
That's correct.
Mr. Crone, you've heard the statement of your attorney and the prosecuting attorney. You intend to plead guilty today in file 23-21520-FH to first degree retail fraud.
Yes, Your Honor.
Do you understand that as a result of the second or subsequent offense notice that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine, or 3 times the value of what was stolen, whichever is greater?
Yes, Your Honor.
You can put your hand down if you like.
Okay.
And in file 24-21715-FH, is it your intention to plead guilty today to count 2, larceny from a motor vehicle?
Yes, Your Honor.
And do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine?
Yes, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting in the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record this morning. Is that correct, Mr. Sneed?
Yes, it is.
Mr. Goldstein?
Yes, Your Honor.
Is that also your understanding, Mr. Crone?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at your trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial, and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Crone, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
And do you also understand that any appeal from the conviction and sentence pursuant to your pleas would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you are giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about June 2nd, 2023 through June 27th, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of first-degree retail fraud?
Yes, I plead guilty, Your Honor.
And how do you wish to plead in charge 24- or in file 24-21715-FH to the charge that on or about August 13, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of larceny from a motor vehicle?
Yes, I plead guilty, Your Honor.
Do you, has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Crone to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Crone, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Goldstein, do you want to establish a factual basis?
I will, Your Honor, and I think there's a potential problem, but we'll get to it in a minute. Let's take file number 21520 first. Mr. Crone, on the approximately between June 2nd and June 27th of last year, 2023, were you in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And specifically on several occasions, were you in the Myers store located in the city of Adrian?
Yes.
And when you were in the store, was the store open to the public?
Yes, it was.
Okay, and did you take merchandise offered for sale by Myers without paying for it?
Yes, I did.
And was it your intention to do that, to take it and not pay for it?
Yes.
Okay, Your Honor, the problem is I'm looking at the police report and it indicates that what was stolen had a value of less than $200. So Mr. Sneed, unless I'm missing something, we have a slight problem. You look on page 6 of the police report, it says items stolen, 16 bags of Morton salt, total value $175.84. So unless I'm missing something, you need to fill me in.
Yeah, if I could have a moment to review that police report, Your Honor.
Go ahead.
I'll go ahead and if it's okay with you, Isaac, I'll go ahead and question on the other case, okay?
Yes, thank you.
Okay. Mr. Sneed, turning to file number 21. Oops, that's the wrong case number. Anyway, the other file, Mr. Sneed, Mr. Crone, on August 13th of 2023, you were in the city of Adrian, County of Lenawee, State of Michigan?
Yes, that's correct.
Okay, and did you remove from a motor vehicle property belonging to somebody else?
Yes, yes, I did.
And that property belonged to an individual by the name of Rodney Hill?
Yes,
And that was a speaker or some stereo equipment?
yes, that's correct.
Did you have any permission to do that?
No,
Okay. And was it your intention to deprive Mr. Hill of that property?
yes.
I think that covers that case, Your Honor.
Okay.
Your Honor, if I could address Mr. Goldstein regarding the value.
Yeah, go ahead.
Dave, I'm looking at page 5 of 8 of the police report. The third paragraph had indicated that on June 23rd, there were approximately 57 bags of salt totaling $626.43.
Yeah, I do see that, but on the next page, it talks about 16 bags. So that's where I was getting confused.
Yeah, understood. I would just like to use that as the factual basis.
That's fine. Mr. Crone, going back to the other case, the retail fraud case.
Yes.
Did you take a total over different days of approximately 57 bags?
Yes, yes.
Okay, and you don't have
I
any
believe
questions
so.
about-
I didn't count them.
Well, but it was a substantial number.
Yes,
And you don't you don't doubt that the total value of those was over $200.
that's correct.
Okay, I think that clarifies it, Your Honor.
Yeah, people are satisfied, Judge.
I'm satisfied.
Has the court complied with MCR 6.302 B, C, and D, Mr. C?
Yes, thank you.
Mr. Goldstein?
Yes, Your Honor.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Crone has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for May 24th at 8:50. Does that work?
A moment, Your Honor. Yes, May 24th. Yes, Your Honor.
Okay, so May 24th at 8:15. Mr. Crone, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, I will, Your Honor.
All right, and I'm going to put you in a breakout session with Ms. Walsh from the probation department so that she can collect your contact information.
Okay.
Ms. Walsh, keep in mind that we do want to have him screened for drug court.
Will do.
All right, thank you.
Okay, Mr. Malero, are you ready to proceed with Mr. Paulding?
Yes, I am, Judge.
Okay, so we are on the record in files 23-21326-FH and 23-21449-FH, People versus Bush Lee Paulding. We are here today for hearing on alleged contempts for violation of bond conditions and also a pretrial conference. So first, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
Salvatore Malero on behalf of Bush Paulding.
All right, so Mr. Malero, Mr. Paulding was arraigned on the contempts, I think Monday, and we set this over for today. So where do we stand with those at this point?
Judge, due to the nature of this particular case, I'm gonna ask to adjourn this 2 weeks so that I can talk to Mr. Paulding and the prosecutor and see what we can do about some things. So that'd be the basis for my report.
2 weeks would be May 1st. Ms. Arnold, anything that you would like to address?
No, Your Honor, I believe that's appropriate.
Okay, so May 1st at 8:15. Mr. Malero, would you prepare that stipulation in order, please?
I will, Your Honor. Thank you.
All right, Mr. Paulding, then you can let the officer with you know that you're done with court for today, and we'll see you back on May 1st.
Thank you.
Thank you, Judge.
Okay, Mr. Murphy, are you going to need a breakout session with Ms. Perez?
Yes, Your Honor, if I could.
They hold that cover. I hear every little fucking minute.
Perez?
That's mine right there. Hello?
Ms. Perez?
Yeah, hi, I'm sorry. Hello?
I'm gonna put you in a breakout session with Mr. Murphy.
Okay.
All right. I apologize, Ms. Walsh. I clicked the wrong button. Were you finished speaking to Mr. Crone, or do you still need time?
Just Mr. Crone, somebody will get a hold of you from our office, okay?
Hello?
Can you hear me?
Yes, it just went out.
That's okay. Somebody from our office will be getting in touch with you, okay?
Okay, thank you
Okay.
very much.
Thank you.
Okay.
Okay, so we can go to Mr. Dupree. All right, we are on the record in file 23-21326-FH, People versus Bush v. Paulding. I'm sorry, read the wrong one, so let me find the right one. There we go. So we are on the record in file 24-21759-FH, People versus Jeremy Allen Debris. We are here today for an arraignment in this case, and we are proceeding today by video conference. So first, let me ask the attorneys to place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Ron Underwood for Mr. Debris.
All right, and Ms. Underwood, does Mr. Debris wish to have the information read?
Your Honor, at this time, we would waive the reading of the information, acknowledge its receipt and the receipt of the witness list and request for discovery. And we would ask the court to enter a not guilty plea on Mr. Debris' behalf and set this for
Right. And a not guilty plea for Mr. Debris and set this for a pretrial conference on May 22nd at 8:15 a.m.
Thank you, Your Honor.
Anything else we need to address with this case today?
No, thank you.
All right, I do see in the file, looks like we need Mr. Debris' fingerprints, so I'm going to do an order for fingerprints as well. All right, Mr. DeVries, you can let the officer that is with you know that you are done with court for today. Okay, and then Ms. Underwood, you had asked about a warner, but I don't have a warner on my docket today.
Okay, thank you.
Thank you. Okay, Mr. Stewart, can you hear me?
Yes, I can.
All right. Your attorney, Mr. Murphy, is speaking to another one of his clients right now. As soon as he's done with that case, I'll have him speak to you.
Okay, thank you.
Okay, we are on the record now in file 23-21664-FH, People versus Teresa Renee Perez. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Ms. Perez.
All right, and Mr. Murphy, where do we stand with Ms. Perez's case today?
Your Honor, in regards to Ms. Perez's case, my understanding is that there's an offer for her to plead to a retail fraud second, a 1-year misdemeanor. I think that may have been, I'm not sure if the court's gotten amended information containing that or not, but Ms. Perez does wish to, again, enter a plea, accept that offer today and enter a plea of guilty to a retail fraud second, a 1-year misdemeanor.
Okay, I do not have that amended information yet. Oh, sorry, I think we do. There it is. Yeah. Okay, yeah, I'm sorry. We do have that. That was filed back on. Okay, so Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is.
Ms. Perez, would you raise your right hand and let me know when you have it raised, please?
Yep, I have it raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Teresa Renee Perez?
Yes, sir.
Ms. Perez, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to second-degree retail fraud?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine or 3 times the value of the property stolen, whichever is greater?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is.
Mr. Murphy?
Yes, Your Honor.
Is that also your understanding, Ms. Perez?
Yes, sir.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Perez, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Oh, yeah, yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
And do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about June 26, 2023, in the city of Tecumseh, County of Lenawee, that you did commit the offense of second-degree retail fraud?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Perez to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Perez, has your attorney promised you any particular sentence or estimated what your sentence would be?
I'm sorry, what now?
Has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
All right, Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Now, just for clarification, this case involves, I think, 2 instances. So, Ms. Perez, were you indeed in the city of Tecumseh, the county of Lenawee, state of Michigan, on June 26 and August 26 of 2023, or about those dates?
Yes.
Okay, those dates, did you enter the Bush's Value Land retail store, grocery store?
Yes.
And now that those dates when you entered, was that store open for business? Was it during the regular business hours?
Yes.
Okay, and would you agree that you tried to take without paying for items from the store that totaled about, well, less than, more than $200, but less than $1,000?
Yes.
Okay, and it was your intention to take those items without paying for them, correct?
Yes.
Okay, Mr. Snee, this is where I'm not exactly sure how much was taken. That's why I was going to ask simply that the amount of restitution ultimately be determined by probation at sentencing. But again, Ms. Perez agrees that the value is between 200, but less than 1,000.
No objection to probation setting restitution.
Your Honor, I believe the factual basis has been met.
Mr. Sneed, are the people satisfied with the factual
Yes.
basis? Has the court complied with MCR 6.302 B, C, and D?
Yes, Your Honor.
Yes, Your Honor.
I will accept the plea that has been given understandably, voluntarily, and accurately. Ms. Perez has had full knowledge of her rights and she's had competent counsel. The court's not made any agreement regarding the possibility of plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for, well, let's see, this is misdemeanor. So to the district court probation department for a pre-sentence investigation. And we'll set sentencing for May 23rd at 8:15 a.m. Ms. Perez, you will need to report to Mike McCarron in the district court probation office on the first floor on Tuesday at 8 a.m.
The 23rd?
Correct.
Okay, now you said Mike, you mean downstairs information?
I'm sorry, I couldn't understand what you said.
Okay, you said report to Mike, the downstairs information?
Correct. Mike McCarron on the first floor in district court probation.
Okay, at the 23rd, at what time again you said?
At 8 a.m.
Okay.
Your Honor, I just wanted to clarify because next Tuesday is April 23rd, and Ms. Perez, you need to report at 8 a.m. next Tuesday to Mr. McCarron, and sentencing is May 23rd at 8:15. I know there's two 23rds being thrown around there, so I just wanted to make sure we got that clarified.
Okay. Okay.
Thank you, Your Honor.
All right. Okay, thank you for that, Mr. Murphy. So Ms. Perez, you are all set. You can go ahead and hang up.
All right, thank you.
And Mr. Murphy, do you need to speak to Mr. Stewart?
If I could, please, Your Honor. Thank you.
All right, we are on the record now in file 23-21657-FH, People versus Zachary Allen Stewart. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing behalf of Zachary Stewart.
And Mr. Murphy, where do we stand with Mr. Stewart's case today?
Your Honor, an offer from the prosecution speaking with Mr. McClure about the matter. From my understanding, is for Mr. Stewart to plead to count 1, fleeing and eluding 3rd degree, and count 2, driving license suspended. The remaining charges, any remaining counts, will be dismissed. Now, Mr. McClure agreed that there will be no upfront MDOC. I just wanted to clarify with Mr. Sneed if that statement would mean there's no upfront jail or no upfront prison incarceration, or what that means by no upfront MDOC ultimately. But I believe Mr. Stewart wants to take that just with that clarification.
If I may, Your Honor, it means no upfront MDOC. It does not exclude jail.
All right, so Ms. Murphy, you still want to proceed?
If I could speak to Mr. Stewart just in a breakout real quick, Your Honor, to explain that. That's different than what I think he was understanding it to be.
Okay.
Okay. Okay, Mr. Murphy, where do we stand after your discussion with Mr. Stewart?
Your Honor, thank you for that breakout session. I do apologize for having to have further discussion with my client, but he does wish to accept the plea offer. He does understand what that language entails, and he does, again, wish to continue with the plea offer.
Okay. Mr. Stewart, then would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Zachary Allen Stewart?
Yes.
Mr. Stewart, you've heard the statement of your attorney and the prosecuting attorney. So your intention to plead guilty today to count 1, police officer fleeing 3rd degree.
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 2, operating with a license that's suspended, revoked, or denied?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine?
Yes, I do.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, I am.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. Sneed?
Yes, it is.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Stewart?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove that you are guilty beyond a reasonable doubt, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at trial, to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Stewart, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I do.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I do not.
And do you understand that you're giving those rights up?
Yes, I do.
How do you plead then to the charge that on or about December 1st, 2023 in the city of Morenci, County of Lenawee, that you did commit the offense of police officer fleeing 3rd degree?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about December 1st, 2023 in the city of Morenci, County of Lenawee, that you did commit the offense of operating with a license that's suspended, revoked, or denied?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
I do.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Stewart to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Stewart, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record this morning?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Murphy, would you like to cover the factual basis?
Yes, Your Honor. Thank you. Mr. Stewart, were you indeed in the city of Morenci, the county of Lenawee, state of Michigan on or about December 1st, 2023?
Yes.
And on that date, were you operating a motor vehicle on a public highway?
Yes.
Okay, and while you're operating that motor vehicle, was your license suspended?
Yes, it was.
Did you know it was suspended?
Yes, I did.
Okay, and while you're operating that motor vehicle, did a police officer try to pull you over?
Yes.
Okay, and you saw those lights in the back of your rearview mirror, correct? From the police
Yes, I did.
officer?
Yes.
Okay, and you did not stop, correct?
That is correct.
And indeed, you accelerated over 35 miles an hour to get away from that officer, correct?
Correct.
Okay. Yeah, I believe we've satisfied the factual basis on both counts.
Mr. Sneed, are the people satisfied with the factual basis?
Yes, Your Honor. Thank you.
Has the court complied with MTR 6.302 B, C, and D?
Yes, it has.
Yes, Your Honor.
Okay, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Stewart has had full knowledge of his rights, and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or a possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as has been discussed on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for May 24th at 8:15 a.m. Mr. Stewart, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay.
And I'm going to put you in a breakout session with Ms. Walsh from the probation department so that she can collect your contact information.
Copy that.
Okay.
Thank you, Your Honor. You have a good day. That was all that I had scheduled, I believe.
Yeah, thank you, Mr. Murphy. And then Mr. Daly, are you here for Mr. Bussing?
No, Your Honor. I thought there was a 11 o'clock hearing on Wednesday.
I have a hearing on Mr. Silvertooth, but I don't have anything on Mr. Winstead.
Okay, well, I just wanted to be here and to address the issues of a joint trial.
Okay. Because I need to get the Silvertooth file. How you doing, Jim?
I'm doing good, sir. How are you doing?
Hanging in there, you know, man. You know.
You hit 70 and things started happening. Things to worry about it. You know, tell you. Your wife applied for that job. That is Williams. She sues the county.
Am I done?
I just believe, yes, you're all set, Mr. Stewart.
All right. Thank you very much. Have a good day.
You too.
Up there. Sam,
Hi, Francis.
Hi.
yeah, there's the word. We knew it was something.
Yeah, if you want to do anything about it.
Yeah.
I'd get a hold of Tony, and I can help you out, Tony, soon too.
Yeah. No.
That heights destroyed it.
I talked a little bit about it. Don't believe it. It's that story. I'm not telling you what he told me. I'm just saying it's too bad that both of you.
I'm just putting back what I found. Like, yeah, I found it. I did, because I was in there going crazy. Okay. I know.
Yeah.
You're cute today. See, we can kind of slip. We can kind of slip. It's paying off.
No, I wouldn't definitely scale this morning. It's not even that pounds. So.
You don't go.
Appreciate it.
Hey, how's it going?
It looks like PM on that one, whatever.
Okay.
Yes.
I know I think Jackie's coming.
Okay, you want to hold for me?
And then again, could we look in the silver tooth? Silver tooth? Thank you. Bye.
Your Honor, could I inquire about a couple cases that we have on our calendar?
Yeah.
One was People v. Harley Busing. Looks like it was adjourned over today, according to our notes.
So that has been adjourned to May 15th at 8:15.
Okay. And the other one was Michael Wilsey. It was an MDOC file.
He waived arraignment. See if I can find the date. His pretrial is May 15th.
Okay, great. Thank you. Have a good morning.
Great, thank you, you too.
Are we all set for the docket or what am I missing?
So I've got one more on Paige Marshall.
Okay, okay.
And we're just waiting for Mr. Malero to get back from Judge Anselm's court.
Okay.
Okay, Mr. Dagger Margosian, are you there and ready to proceed with Mr. Silvertooth's motions?
Your Honor, we can proceed.
Okay.
Judge, Miss Wise is on her way.
Okay. I've got her on Zoom,
Oh, okay.
I think. Ms. Wise, are you there?
I apologize, I'm here.
Okay. All right, we are on the record then in file 23-21612-FC. People versus Kenyatta Tywin Silvertooth. We are here today for hearing on two motions. The first is a motion to quash bindover, and the second is a motion to sever the trial. We are proceeding today by partially by video conference and partially in person. First, let me have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Silvertooth.
James Daly on behalf of Mr. Winstead.
Okay, and so Mr. Daly is here with respect to People versus Gage Winset, who is related to the motion to sever. So Mr. Dagger Margosian, let's start with the motion to quash the bindover. If you have oral argument on that, you can proceed with it now.
Your Honor, I will rely mostly on what was submitted to the court in writing. It is a general request that the information and testimony provided at the preliminary exam in district court in front of Judge Shadler was insufficient for bindover, and we'd ask the court to find as such after reviewing the motion as well as the transcripts.
All right, Ms. Wise, do you care for any argument?
Did you receive an answer in this matter?
I did. Oh, I'm sorry. I didn't know if you're talking to me or the court.
Okay. As far as motion to quash, no, Your Honor, there was no error, and we would ask the court to deny the motion.
Okay, so I've had a chance to review the motion as well as the transcripts from the preliminary examination. The purpose of preliminary examination is to determine whether there's probable cause to believe that crime was committed and whether there's probable cause to believe that the defendant committed it. The prosecutor must present only enough evidence on each element of the charged offense to lead a person of ordinary prudence and contain a reasonable belief of the defendant's guilt. In reviewing the district court's decision to bind over a defendant for trial, a circuit court must consider the entire record of the preliminary examination and may not substitute its judgment for that of the magistrate. Reversal is appropriate only if it appears on the record that the district court abused its discretion. An abuse of discretion is found only where an unprejudiced person, considering the facts upon which the court acted, would say that there was no justification or excuse for the ruling. In this case, a review of the preliminary examination transcripts reveals that there was video evidence at 3:59 p.m. of Mr. Simmons' silver van seen driving south on Center Street in the city of Adrian. At 4:06 p.m., there is video evidence of Mark Silvertooth and Samantha Barrett walking through the Restored Church parking lot in that same vicinity. There is cell phone records that indicate that Kenyatta Silvertooth makes a call to Mark Silvertooth at 4:08 p.m. and at 4:09 p.m. Kenyatta Silvertooth, Gage Winset, and a third individual walked through that same church parking lot in the direction of Diana's Market or Mike's Market. At 4:10:22, there are cell phone records which indicate that Mark Silvertooth called Kenyatta Silvertooth. And then at 4:11 p.m. on the date of the shooting, there was video evidence that Mark Silvertooth, Samantha Barrett, Kenyatta Silvertooth, and Gage Winset, and that other individual were walking back from the direction of Diana's Market toward Mark Silvertooth's home at 418 Church Street. So that video evidence is consistent with the witness testimony regarding the parties, the people's movements in the time shortly before this shooting occurred. There is testimony from Robert Allen that shortly before the shooting, he noticed a black Jeep, and he saw two people in that black Jeep. He also testified that he could see that the driver was wearing a mask. And he testified that the occupants of the black Jeep were suspicious to him in that they were looking up and down the street as though they were looking for someone. He further testified that a silver van turned left in front of that black Jeep and that shots were fired from that black Jeep at the silver van. At 4:18:30 p.m., there's video evidence of the shooting taking place. The video shows that there are shots fired from a black Jeep, and the video evidence has the license plate of the Jeep in it, and that Jeep is registered to Kenyatta Silvertooth. There is testimony that the driver of the Jeep was the shooter, and there was also testimony that Kenyatta Silvertooth did not let other people drive his car. There is cell phone records that indicate that at 4:20:11, Kenyatta Silvertooth calls Mark Silvertooth, and that Mark Silvertooth called Kenyatta Silvertooth at 4:24:13. There's testimony from Mark Silvertooth that Kenyatta Silvertooth told him he was getting, quote, the hell out of here because somebody was trying to kill him or wanted to kill him. And so I believe based on that evidence, I understand that it is a circumstantial case, but circumstantial evidence is sufficient for purposes of a bind over. And I think that a person of ordinary prudence or caution could conscientiously entertain a reasonable belief as to Kenyatta Silvertooth's guilt based on that timeline, particularly in that within 7.5 minutes of the shooting, he is in the area. We know that it is his automobile that the shots are fired from, and there's testimony that he did not let other people drive his vehicle. So I think that the timeline lays out a situation in which a reasonably prudent person or a person of ordinary prudence would conscientiously entertain Mr. Silvertooth's guilt. So I don't believe that the district court abused its discretion in binding this over for trial, and I would deny the motion to quash. Mr. Dagger-Margosian, there's also a motion to sever. Is it your intent to proceed with that today, or what did you want to do?
Your Honor, we filed the motion to sever to preserve that issue. I think at this moment in time, we would ask to defer hearing on that motion until the final pretrial for next week. If the court and if the people are okay with that, I'd like to just defer that issue for now.
Okay, Ms. Wise, do you have any issue with that?
No, Your Honor.
Okay, so the final pretrial is set for next week then?
Yes.
April 24th, so next week, April 24th, so we'll reset it for hearing with the final pretrial in April.
Thank you.
Thank you, Honor.
All right, Mr. Dagger-Margosian, could you just renotice that hearing so we have it in our file?
Will do, Your Honor.
All right, thank you for your time then. You can go ahead and log out. Mr. Silvertooth, you can let the officer that's with you know you're done with our court for today. And Jayla, it was nice to see you again. Sorry.
Nice seeing you, Judge.
Sorry we didn't have the hearing that you came for. Okay.
Yeah.